wherever you are. This is our seventh of a webinar series dedicated to the problem of Interpol abuse and defending the rights of individuals on the international wanted list. Today, we're going to talk about a very interesting and pressing topic, challenging Interpol's immunity. Um, our webinars from the very beginning are going to be a free flow in a free flow discussion forum. Usually, I do an intro, but again, because it's more non-conventional thing, I will yield to Anna Ümihir, who will give this introduction, and then also with us today is William Juliet from WJ Bocon in France, and Vanya Costa-Ramos, an attorney in Lisbon, Portugal. We have a great panel today, and we're looking forward to our discussion and your questions. Anna, please.
Thank you very much, Yuri. I have the privilege to have been with you with the beginning of this webinar. When you did the first webinar already, I remember we discussed immunities and we thought, oh, we shouldn't start with this topic. It's too specific. And I'm very happy that we finally reached that point because it's one of the most interesting issues, actually. Yeah, I'm a criminal defense lawyer in Berlin, in Germany, specialized on extradition, and I will now try to share my screen with a small PowerPoint to just give you a brief introduction in this topic of immunity. Hold on. Can you see the screen?
Just a second.
Can everybody see the screen?
Yes. Yes. If you can maximize the window, enlarge it.
I cannot. It's already the largest.
Oh, okay.
Sorry. So I'm gonna talk just briefly about the immunity issue of international organizations in general, and then on Interpol's status in specific. So under international public law, there's the Vienna Convention on Diplomatic Relations of 1961, and that already provides for immunity of diplomatic agents in its Article 29. But this one relates specifically to diplomats, embassies, consulates.
And I'm so sorry if I'm sorry I'm interrupting you. Can you please try and share the screen again, and maybe we can maximize the window.
Mm-hmm.
Okay, just a second. Yeah.
No?
Well, I guess no. I think it's fine now. Yeah, please go ahead. Sorry.
Yeah.
Yep.
Okay. So with international organizations, they have different ways of protecting their staff and from criminal prosecution in the domestic international states. And they have different types of legal basis for this. So one is general agreements on privileges and immunities that they adopt. Another one are bilateral agreements on privileges and immunities with respective countries, for instance, where they have their location or where they have a meeting. And another one are headquarter agreements, where the headquarter of the international organization is. Here are some examples. So the Council of Europe has general agreements, the International Criminal Court, European Space Agency, the ASEAN organization, the OECD has bilateral agreements with all the different countries. NATO has both. They have a general agreement and they have specific bilateral agreements, and you find headquarter agreements, for instance, with the International Red Cross, with the European Central Bank in Frankfurt, and with the OPCW. So what does that mean for domestic prosecution? It's not that easy because it depends not only on the specific organization, but also on the implementation into national law when it's a dualist country. For instance, in Germany, one example of case law is was a guy who was working for the European Patent Office in Munich and wanted to be exempted from paying the broadcasting license fees. And the administrative court of Berlin said that he was not immune and that he had to pay these license fees because the agreement that was concluded between Germany and the European Patent Office only referred generally to the Vienna Convention and similar provisions which did not make reference to broadcasting license fees. Whereas with NATO, NATO had a specific bilateral agreement that made reference to these fees. Then other courts, a Belgian court had to tackle the question of immunity when somebody exhausted the remedies with the West European Union in Belgium, and the Dutch Hoge Raad with the European Patent Organization in the Netherlands. And there, both courts decided that there was immunity and there was no domestic jurisdiction applicable because the internal remedies sufficed to deal with the matter. So now coming to Interpol status, the first question is Interpol an international organization at all? So to have an international organization, usually it has to be established by an international treaty or by another international legal instrument. And this treaty has to be signed by at least two subjects of international law, and it has to have legal personality. When we look at Interpol, it is not established by an international treaty and it is not signed by subjects of international law. The constitution has been agreed by senior police officers and diplomats. It was never submitted to national parliaments for ratification. However, according to Interpol, at least, it has legal personality. And they argue that there is a number of its member countries who treat it as an international organization, that government ministers attend the annual assemblies, that Interpol is mentioned in international treaties on extradition, and that many countries have recognized its Interpol travel document as being akin to a diplomatic passport. This question about Interpol status has also been the subject of a question before the European Parliament in 2013, where somebody asked whether the EU considers that Interpol enjoys legal personality, and if so, what courts can pursue action against it, whether it enjoys immunity from the European Community laws. The Commission in 2014 answered that in practice, whereas formally it's not an international organization, in practice, Interpol is treated as such. With legal personality both by countries and international organizations. They said Interpol is not accountable to an international court, being a sui generis organization. Though Interpol has no executive powers of its own and depends on the information of its members, it is not subject to EC law. However, regarding remedies, the Commission said you can address the national authorities because they are members of Interpol. But now this is only the introduction, and you see that there's a lot of question marks about the status, and it's highly debated. And this is why I'm very interesting to listen to my great colleagues to hear what Vanya and William have to say on this matter.
Thank you, Anna. So William and Vanya are going to talk about the European Union approaches, but more specifically, William will talk about French law. And there is a very interesting, very recent case there. and then Vanya will talk about the European Court of Human Rights jurisprudence. William, if you'd like to take over, and to our viewers, please feel free to ask questions in our chat. We'll have a Q&A after our discussion. William, can you hear us? Just a second. I think we have another show.
He's been kidnapped.
Interpol red notice.
William, can you please try and just a second. Vanya, do you mind switching with William? Just a second, maybe it is okay. It is William.
Can
Yes,
you guys?
we got kicked out.
Okay,
yes, we can hear you.
Yeah,
okay, yeah. So
I heard.
We can.
I got lost on my kidnapping. I just heard that last word from Vanya. I was not. I was not kidnapped.
Okay, we have you
I'm back.
lost.
Can you guys hear me?
Yes, of course. Yeah, I was just saying that, so Anna, I think Anna and I said that you and Vanya are going to talk about the topic from the European Union standpoint, but more specifically, you're going to talk about French law and the most recent cases in France, which are very, very interesting. And then Vanya will talk about the European Court of Human Rights jurisprudence.
Okay.
Go ahead.
So maybe the starting point is the headquarters agreement between Interpol and France, because as I imagine all you guys know, Interpol is based in France, in Lyon. There is a headquarter agreement, which is the legal framework that bridges Interpol with our beautiful country, France. And within this headquarters agreement, there is a famous Article 5 that says that the organization shall enjoy immunity from legal process, except in the cases specified below. The waiver expressly results from clauses in a contract, a civil claim for damage arising from an accident caused by a motor vehicle belonging to the organization, so that's roughly road traffic accidents, and second, the organization might expressly waive its immunity from legal process in certain cases, which is quite nice, but I am not aware, despite in some cases people having pushed quite hard, that they have waived their immunity. I have one example coming in a second where actually they were brought to court and they didn't waive anything. They, on the contrary, had a lawyer who went with the immunity argument successfully, and there was no examination on the merits of the application because the immunity exception was received by the court. So that is what I'm going to speak about in a minute. This first interesting but non-favorable decision within French case law. But just before that, one word, because we will also have a go discussing a bit later legal remedies and how we could try and figure out to attack again Interpol in France and set aside immunity. That will be around the questions of effective remedy. So there has been one change in the headquarters agreement in 2016, where Article 24 was put in place, and this is a reform. And quite interestingly, when there are reforms within Interpol, it is not only because we all Interpol practitioners are doing a very good job in convincing them that they have to improve their rule of law mentality, but also because they fear that we are going to possibly challenge them successfully again in court. And before that happens, they sometimes put in new provisions. And that is what they did in 2016. The provision says, unless the parties in the dispute decide otherwise, any dispute between the organization and a private party shall be settled in accordance with the optional rules for arbitration between international organization and private parties of the Permanent Court of Arbitration by a tribunal composed either of 1 or 3 members appointed by the Secretary General of the Permanent Court of Arbitration, which in itself could have been a good progress, except that the third section of this provision says the procedure specified in Article 24, Section 1, which I just read, shall not be applicable to disputes whose origins lie in the application or interpretation of the organization's constitution or its appendices. So roughly that is nearly all of what could be of interest, maybe except road accidents, including those disputes relating to the processing of data in Interpol's information system and those relating to the employment conditions of the organization's officials. So that's actually quite funny because they put in a jurisdiction arbitration clause, but that excludes any matter in relation to red notices, for example, but any data matters, and even more largely, widely, interpretation or application or of the Interpol's constitutional and appendices. So it seems quite clear that what was opened was closed for what could be of interest in all the cases we are handling with people, and I'll get to that in a minute, who might get arrested for the worst of these cases, sent over somewhere and possibly tortured, ill-treated, blah, blah, blah. So that is for the legal framework. Case law, the only attempt when a decision was published, I actually had quite difficulties putting my hands on, but now I've got it. Is a very interesting decision, dated 17th of March 1993. So that is 31 years ago, and this was a civil application summoned against Interpol for a Turkish individual who was explaining, I won't go in the details, but I'm happy to share this, who was explaining that he is a political opponent, etc., and that he was not happy with the fact that he could be arrested because of Interpol red notice being diffused, and that he wanted Interpol to be considered liable in having him in the system. The judge retained that Interpol was not a non-governmental organization, but that it was an intergovernmental organization, intergouvernemental, that it was then constituted by member states, France and Turkey being part of these member states, and that following this status, it was needed that the judge looked not at French law, nor actually, I think, even wrote international law, which is maybe not a very strong point of this judgment, but that it was needed to look into the headquarters agreement, and that under Article 5, the Interpol intergovernmental organization was immune, and that for that reason they would not look into the case. So that was 1993. So what since? What since is not yet direct challenges against Interpol on data matters around the GDPR area, but possibly not only, because one could think of other legal provisions that would be put forward in a summon against Interpol. But there is interesting case law that was rendered by French courts, not against Interpol, but against other or international organizations. And I can share also these references if someone wants them. Please just write to me. But and to stay short, there is one decision which is they are all from the Cour de Cassation, so the French Judicial Supreme Court, and most of them, interestingly, actually I think all of them, from the chamber dealing with labor law, and they all related to labor law issues. One had to do with the African Development Bank and its immunity. One had to do with, so that is the 2005 decision. Then one had to do with the BEAC, which is also an international organization which had to do with the Republic of Cameroon. And then there was a third one which had to do with UNESCO. And the main takeaway from these three decisions, two of which denied immunity, which is what could be interesting for us, was on the grounds that these organizations had not put in place within their own system of functioning a proper legal remedy, or at least course of action, to seek legal remedy with sufficient guarantees of impartiality and equity. So that is where we could have, and I can't say too much, but no, for two cases, one that has been made public, but I don't know anything from the inside. But I know that I think there is a French attack against Interpol requesting that immunity is set aside in regards to this guy who was extradited to Bahrain, I think, and severely tortured there. I also kind of think that there's an ongoing matter as a follow-up of a case that has been made public, where Mrs. Meng, who is the wife of the former Interpol president who disappeared from France and then reappeared in China, making amends for having supposedly committed crimes in China. There was an arbitration attempt made against Interpol by his lawyers, amongst which a French colleague and esteemed, very good criminal lawyer and friend of mine, Emmanuel Marcini, but with also an international team. and it is understood, but the decision is not public, that it didn't work out because I don't know what their grudge is against Interpol, but I imagine that it was considered that maybe this arbitration attack fell within what was considered not to be outside of this immunity provision. I don't know for sure that that was why it didn't work out, but I understand that they might be now following this course of challenging in France, maybe around these Supreme Court decisions on other organizations connected with, if they are indeed doing what I think they could be doing, bringing this additional absence of legal remedy, because they tried the arbitration route and that was not successful. So that is an additional element of evidence to show the French judge, look, I mean, nothing can be done. So that's for the case law. And the last word, because I don't think that I need to put more in it, and obviously the discussion will be of maybe more interest than just continuing on and on, just presenting things. There will obviously be discussions before the French court about around this notion of, is there an effective remedy? Is the legal course of what can be asked to the CCF enough, good enough, or not, on the grounds of impartiality, of equity, of not there being a second shot of requesting a proper judicial review, a second judicial review? But I will leave the floor to Vanya on these more European high level provisions of what is a proper remedy under European provisions, and possibly also just opening this question. If it was considered that CCF roughly is not so bad, I know we're all kind of pushing, saying, oh, look at that, it's really no good. But I know the French judges will not be kind of super willing to say that Interpol is liable. So we need to be sure that they could come saying, oh, look, you've got a recourse. It's not, you've got nothing. And in the French case law, there was actually nothing at all when immunity was set aside. So maybe it's not perfect, but you've got something, blah, blah, blah. I would suggest that maybe we look into, within the legal remedy area of brainstorming, what is about compensation, and go back to what is said within Interpol rules about compensation, because it's also about that. It's about wrongdoing. It's about link with a damage. We often have damage. The guy's tortured. Wrongdoing is a bit more difficult to bring, but we should be able to be kind of efficient on that on many cases. But then we will say, okay, so, but what about compensation? And I think that on that point, Interpol rules are absolutely non-existent. And I don't recall anything else in Article 39, Section 2, explaining that, you know, the request chamber, when it finds that there's some problem, may decide on other appropriate remedies, apart from taking the notices out. But we don't know anything about what appropriate is. And I have never seen the word compensation anywhere, neither that there would be a fund. And I think that the maybe new reform that will come, because they will be at risk on the immunity, will be about compensation. And that will be my final word.
Thank you, William. I hope. I mean, I think we all hope that that's not going to be a final word.
No, I mean, just on going on and
No,
on without discussion.
no, no. It's a great presentation. It really incredibly very thorough. Thank you very much for it. So I think let's yield to Vanya, and then we'll discuss, because I personally have questions, and I think I'm looking forward to discussing this. Vanya, please, your turn.
Hi, everyone. So it's great to be here with colleagues from everywhere, from US, from Europe, and citizens of the world. And hopefully other colleagues who are watching or following, or just regular individuals will also be sharing their views. So I
Maybe
think
maybe some Interpol guys are watching.
who knows? Yeah, that would be perfect also. We are open to, these are adversarial proceedings, so everyone is able to give their views.
Absolutely, and please, as I said, I'm sorry, Vanya, I didn't mean to interrupt you. Please, to our audience, feel free to post your questions. We'll gladly answer them during our Q&A. Sorry, go ahead, please.
Yeah, sure. Maybe, and because this is a global audience, I can start by saying that I'm going to speak about European law, and at the European level, we have two main sources of law, just to simplify. One is the Council of Europe. It's an international organization, also mentioned by Anna in the beginning, composed after Russia's withdrawal by 46 member states. And let's say I think its most well-known symbol is the European Court of Human Rights, and of course the European Convention on Human Rights. I think, although they are different, but let's say for maybe in the US, when one would think let's go to the Supreme Court and bring this, in Europe one thinks let's go to the European Court of Human Rights. Of course, the EU is a bit more complicated. So in Europe, we also have another organization, which I will not call it an international organization, because it could even be considered a bit more than that. It's a particular entity. The European Union is a smaller group of member states, and as also a kind of Supreme Court. It's the Court of Justice of the Union, which is then composed of several courts. It's not very interesting now for our discussion, but also to understand that when we talk about European law and about challenging Interpol's immunity, the questions that come up are, can we go to the European Court of Human Rights or to the Court of Justice of the European Union to bring the matter of Interpol immunity, or to challenge its validity under these laws, and to normally to try to get some redress for purported wrongdoing by Interpol, just like William mentioned, to get some kind of compensation for this wrongdoing. Maybe just to end the suspense, I will say that to the extent of our knowledge, until very recently, the European Court of Human Rights has not ruled on any matters concerning directly the immunity of Interpol, so that no one has yet challenged, or if they have, the case has not yet reached a decision that is known to the public. So until now, no one has challenged Interpol's immunity before the European Court of Human Rights. And why is that also a case? It is also difficult because the European Court of Human Rights is a court that can only be activated. It only has jurisdiction to rule after individuals have exhausted the remedies that they have at a national level. So to use the case of Interpol, Interpol is based in France. Let's imagine this is a case of France. Let's say a case of a red notice issued by a third state outside of Europe, so it has nothing, it's not a state party to the European Convention on Human Rights. Of course, if one is to try to challenge Interpol's immunity at the European Court of Human Rights, one will first have to go before the French courts and try to sue Interpol before the French courts, arguing what William just stated, that this immunity is not acceptable under French law. What does the European Court of Human Rights say in respect of immunity, more generally speaking, of international organizations? The court has a doctrine that is called the alternative means doctrine, and this doctrine was established in the 90s, also in cases concerning labor disputes within international organizations. And basically, the court follows the reasoning that I will explain. So, the member states of the European Convention, like France, Portugal, Germany, all member states, they have a duty to ensure that the rights and freedoms established in the convention are protected within their borders and any territory which they can control. Um, of course, the convention does not forbid states to work together and to set up international organizations to which they may transfer certain tasks to do them most effectively. However, the convention demands from member states that when they do this transfer, so when they cooperate within an international organization, that this is not used to circumvent the protections of the convention. Let's say if France cannot detain arbitrarily a person, it cannot give powers to an international organization to do so, and then that international organization would be exempt from any legal process because of their immunity. So the court has established a case law that states that immunity is immunity from legal process is admissible under the convention only if the states have established alternative means, alternative remedies, alternative processes that would be in compliance with the requirements of the convention. To translate this to Interpol, let's say Interpol or the states, namely France, when giving Interpol immunity and cooperating, allowing her to have the headquarters in France, would have had to make sure that Interpol also has sufficient remedies, both in procedural terms and also in terms of the redress that can be obtained in the case of wrongdoing before a court. So, what has happened so far in the case law of the European courts? This doctrine has been applied in a set of cases. Often the court has found no violation of the convention. What is the relevant article? It's Article 6, paragraph 1, the right to a fair trial and the right to a decision by a court, by a tribunal. Article 13 would also be relevant. It's the right to an effective remedy for violations, but normally the court, because Article 13 has a narrower scope, the court will hear the complaints about Article 13 under Article 6. So if you are thinking of suing Interpol and doing so, if you are thinking of going before the European Court of Human Rights, first you'll have to exhaust your remedies. And where can you do it? You could do it obviously in France, where Interpol has its headquarters and of course the country that has signed the immunity agreement. But likely if the violations would also be connected to other member states of the European Convention on Human Rights, let's say the Interpol Red Notice also comes from one of those states, you could also consider to challenge it to try to sue in that state. But this is a bit more difficult. Let's not go into technicalities. Also, many of the problems that we face are about states that are outside of the Council of Europe also, so there is no chance of applying the European Convention on Human Rights to them. Okay, this is an idea maybe for those who are thinking of suing Interpol. If you exhaust your domestic remedies, then you may try to go and make a challenge before the European Court of Human Rights. I'm also happy to give you, let's say, the first precedent was a case of Waite and Kennedy versus Germany, but well, if anyone is also interested, I'm happy also. I worked together with William on this matter and with other colleagues from William's office, and we're happy to provide the references to the cases. There is a case where this alternative means theory has been excluded. It was a case where the matter was about the United Nations, so as international organization and connected to matters of war. And in that case, the court has not applied this theory. It's the case of the mothers of Srebrenica, but there are good arguments to think that the court did not reverse the theory. It's the special features of the UN and of that case that led the court not to apply this alternative means theory. On the other hand, all cases that applied the alternative means theory are cases under labor law disputes. So also none of them has to do with arbitrary detention or violation of the right to privacy in the processing of personal data. So this is also a challenge open if one tries to explore European Convention on Human Rights Law. And maybe not just to give you a little flavor, this is even much more complex. So I'm just going to give a very short flavor to this topic, which is the matter of EU law. Does EU law apply to Interpol? This is even more complicated. And it's more complicated also for those who are maybe not outside of the EU and of the EU system. One also has to know that bringing a challenge before the courts of the EU requires that there is an act by a EU body or by a member state. By member state, you cannot go directly challenging in most cases before the courts of justice. You have to challenge before the domestic courts anyway. But let's say the courts of the EU are normally courts where you can only get to by launching a procedure at domestic level. Let's say someone tries to sue Interpol in France, as has been the case. One could raise EU law, either as a persuasive argument only, or one could try to bring up the issue to argue that EU law is also applicable to the immunity agreement, let's say, and to the cooperation to the act that France is a party of when signing up this agreement. This is highly complex. I think we could have a session only about this. So what I wanted to give you a flavor of is about the fact that there is an ongoing negotiation between the EU and Interpol to conclude an agreement. I don't know. I don't have an inside view about this. Maybe for a future session, we could have someone from the parliament, because the parliament in 2022 was also issuing its opinion on this. So I'm not sure, it's quite secretive. But were the EU to do an agreement with Interpol that would regulate certain relations between the EU and Interpol, we may, of course, have even a better basis to argue that EU law would be applicable to Interpol. And of course, the main point is the data protection rules under the Charter, the treaties, and the data protection law. I have a feeling, this is only a feeling, so I don't have any inside information, that this is the big problem for this agreement, among others. And there is a discussion of scholars about, in general, whether the RGPD, you may have heard of the regulation, the general regulation on data protection that was approved in the EU, that has very stringent regulations, and is also a partner to the directive on the data protection in respect of activities of law enforcement authorities. These are EU laws about data protection. They are quite strict, and they require, among others, the possibility to have an independent authority to which you can complain of violations of the protection of your data, and also access to courts to challenge violations of your data. So there is discussion in scholarship on whether these laws would even apply to international organizations in general, and one could then discuss whether this would apply to Interpol. I have not seen any official positions about this, but so I'm guessing this is a strong and very critical and delicate point of negotiations of this agreement, because the requirements of your EU law are very high. So maybe Interpol's system does not comply with them as it is today. And obviously, this is a big challenge. So no one, to the extent of my knowledge, has tried also to invoke this. But if there is a case ongoing in France, one could also try to argue in that case to which extent EU law is applicable, namely these requirements of the treaties, the Charter, and the data protection rules that require that states give people an effective remedy. And then it's quite similar to the European Court of Human Rights in terms of substantive requirements of what is an effective remedy, but the EU law is even more demanding because it does require an access to a court at a certain point, or an entity that has to have the features of a court. I think I will not speak more. I think this is already enough and quite complex matters, but I'm happy to also answer any questions and to engage in the discussions with everyone.
Can I just add one thing for the people who are not from the EU? I think for Vanya and William it's very obvious, but for the non-EU lawyers, just to notice that there's no way for a party to domestic proceedings, to bring the case to the European Court of Justice, to the EU court. It's only the judges who can request for preliminary rulings. So even if there's a case where you could argue that EU law was affected, it's not in your hands as a lawyer to bring the case to the European Court.
Yes, maybe to add to that, there is only, I was stating before, this is all very complex because unless you have a EU body that to connect, and then you can launch an action for annulment, possibly, if it's not excluded by the legal act. But there is some cases, if there is a blatant violation of EU law by the member states, including by their courts, where you can launch an action for tort. Let's say you can sue your member state for damages for a breach of EU law. But as we stand now, we are even in a point where no one would know if these rules of EU law even apply in the context of Interpol and of the immunity agreement. So it's very premature to already think about it. But this is, I think, for the brainstorming, something that has to be discussed. Yeah.
Thank you. What about? I have a question, and I think it's related to what Vanya just said. And Vanya, please correct me if I'm wrong, but that's how I mean that's how I understand your argument. Maybe it's a potential argument that trying to like sue, for example, the French government over entering into this, so to speak, entering into this agreement with Interpol, because Interpol doesn't comply with the due process requirements and does not provide the victims of abuse with the redress mechanism as it should be. Is that what you were trying to say?
It's a bit more complex. It's a two-step. Yeah. So let's say you would have to sue Interpol before the French courts, right, argue that immunity should not stand in the way of this case because Interpol does not have the necessary redress mechanisms. When this argument is already made also on the basis of the European Convention of Human Rights and the case law of the court and the requirements that the court argues, and then if you lose, let's say if the French courts say, I don't agree, immunity stands, then you can make a complaint against France, who is a member state of the convention, before the European Court. And William may have something to add here.
Yeah, there's sure. There's and I was going to jump in after Anna's comment, but I was muted. And thanks, Vanya, for helping me out once again. Yeah, there are two routes. There's the ECHR one, and that would be what Vanya just said, meaning you would have to exhaust legal remedy in France. So you would need to appeal, then go to Supreme Court, and that's it. And then you could possibly try to have a go at saying, look, France, they're not behaving as they should. Another route would be, and for the maybe non-EU people listening to us, there is another but that is to be discussed, and Vanya is my specialist on this. Whether we would have a shot, or Anna also could maybe help me too, not with the European Court of Human Rights, but with the European Court of Justice, on the grounds of EU law, EU regulations, and or directives or whatever, proper EU material, and not a European Convention on Human Rights, which is not EU per se, and it's much wider actually. And that shot would be that one would need to ask the French court or another EU member state court that would be actioned, but I believe that things are going to happen in France for the reason of their standing, because the organization is based in France. And as Vanya said, maybe via NCB something could be tried, but anyway, it won't change, because for the sake of the example and reasoning, France works. But what we might do actually, I mean, and we're considering it, as we are possibly considering also suing Interpol on a case, whether we would go straight to the French judge telling him, okay, do that. But sometimes what we do when we think that we might get the door slammed in our face, to make the French judge's life a bit more difficult, we complexify a bit the structure, and we tell him, oh, by the way, there is a European EU regulation that needs to be interpreted by the European Court of Justice, and your decision might well depend on what the court has to say, because you're supposed to apply EU regulations, but sometimes you need the help of the European judges who are specialized in EU law. And that is called a question préjudicielle, which is a preliminary question that you address to the French court, saying, okay, you have to postpone your decision, and we ask you to send this question to the ECJ, European Court of Justice, asking them whether, for example, this or that would be compliant with this or that provision of, why not, the Charter on Fundamental Rights, which is kind of the equivalent of the European Convention on Human Rights, or maybe in regard to the GP DI. I always get mixed up with it, because in France it's RGPD, and in English it is the
GDPR.
GDPR, thank you.
You're mute again.
You muted again, William.
Okay, sorry.
There is something with you.
Yeah, that was a wrong move of my right hand. So yeah, maybe trying to figure out whether there would be a preliminary question to make the French judge's life a bit more difficult, knowing that then there would be the question of, okay, would the European Court of Justice consider that they have something to say about this strange body, which is Interpol, but possibly that's another lead.
I think this is maybe if I can chip in.
Of course.
I think the French courts should, let's say, from the 90s until 2023 is where we are now, and I think much has changed. Also, recently I was revising a documentary about Interpol, even the financing, the budget, the activities. So much has changed since the 90s until 2024. I think, even in the way that Interpol operates and how much data is exchanged, etc. And also data protection laws have evolved a lot. So if I were a French judge, I would surely not dismiss a case without entering into detail into this argument about whether immunity still complies with the current status of European law and EU law. And I think asking for a preliminary ruling, like you are stating, is essential, because the first question is does EU law apply? I think that would be the first question of interpretation of EU law, is whether certain provisions of the treaties concerning data protection and also of the then relevant, probably the law enforcement directive or the RGPD or both, whether they apply to Interpol. So this is, I think, the would be a first question. Then the second would be obviously to know whether the let's say the whether member states of the EU would be allowed to enter into an agreement with an organization that, you know, does not, well, that's the second question, whether it complies with EU law in terms of the substantive requirements of data protection, and then, you know, whether the member states would be allowed to enter an agreement with certain features, as the agreement that William has just mentioned. So, of course, this is a very relevant question, and data protection in the EU is a kind of a trend. Everyone is speaking about it. And then it's a bit shocking that one could have an international organization sitting in the EU territory and working with criminal law enforcement, which is obviously a very important task of the member states, but which is exempted from compliance with a very important piece of EU law. So I think I completely agree that preliminary ruling would be very much on point.
Yeah. And I'm not sure. Yeah, I'm not sure that the EU would easily say, okay, I mean, these guys can be completely exempt of this extremely important area of rights to protect. So really interesting.
We had the case. So the reason I asked Vanya that question, because here in the United States several years ago, we had the case Elomari versus the United States. Probably everyone who is interested in the topic has heard about this case at least once. And the court, it was a district court for the Eastern District of New York. So Miss Elomari sued Interpol based on the New York State Constitution. And he claimed that Interpol denied his complaint and then a request for reconsideration. And he also asked for a hearing, and Interpol, the commission did not hold a hearing. And he claimed negligent infliction of emotional distress and violation of his due process rights under the New York State Constitution. So the court dismissed the case based on the International Organizations Immunities Act. We didn't go into merits or anything. So basically, the way International Organizations Immunities Act works here is that the President of the United States can grant immunity to an international organization in which the United States participates. We had this sort of in the United States. When it comes to Interpol, it's been in stages. So in 1983, President Reagan granted Interpol immunity, but there were exceptions. So archives, search and confiscation of, with the exception, immunity with the exception of inviolability. I'd rather read it so that I don't miss anything. Of archives, and immunity from search and confiscation of property and assets, customs duties, certain federal taxes, and social security payments. Then President Clinton in 1995 reversed that order and granted Interpol immunity from customs duties and federal importation taxes. And finally, in 2009, President Obama removed the remaining limitations imposed on by President Reagan. So basically, again, the case got dismissed, didn't go anywhere, unfortunately. But the idea of potentially suing the administration over granting that immunity, the question, because suing Interpol, I think everybody understands, I think it's pretty clear that, okay, it's one thing to sue Interpol, and okay, say theoretically speaking, you win. How do you enforce that judgment? So because say it's in the United States. So what do? Take it to the United Nations? I'm sorry, to the United States National Central Bureau, but the database belongs to Interpol. The U.S. NCB, like any country, any national NCB, is usually a government agency. They can't really do anything with Interpol's database. I mean, in terms of enforcing a judgment, especially national judgment, national court judgment. So that's why I'm interested in that topic. And I know it's very theoretical, but if it's possible to sue the administration, say here, or the French government, in terms of the case we just discussed, over granting this immunity, because I think that Interpol, since the very beginning, has not complied with due process requirements anyway. So this immunity, in my opinion, has been questionable from the very beginning. The Commission for the Control of Interpol's Files, in my understanding, has not been, well, in general, I guess there are certain exceptions, but in general, I think the Commission for the Control of Interpol's Files sort of like hasn't regressed. I mean, there have been some reforms, just that they're not enough to bring it anywhere close to the modern democratic due process requirements. Another thing I wanted to mention, because William made this incredible presentation about and talked about arbitration, and Vanya just raised this issue in terms of financing. So I think these things are related, because the very first time we learned about a success, and the only time that we learned about a successful arbitration against Interpol, was from the Interpol budget. They had to disclose as an expense how much they paid under a settlement, an arbitration settlement. And that's when everybody started questions like, oh wow, Interpol has been sued finally, and somebody won. But again, it's my understanding there was a settlement. So
what was the year of that, Yuriv?
I believe it was several years ago. I won't give you the year right off the top of my head, but I don't know if Ted Bromont is watching us now. He studied that topic extensively. Maybe he can comment on that. We would appreciate it. I'm sure he remembers the date, or at least the year. And by the way, the case, a more recent case, and I think we will go into talk about it. The European Space Agency sued in a French court, and then the court stripped it of immunity, right? Like, can you, William, can you talk a little bit more about that?
Which one?
Or maybe Vanya. So it's very recent. It was literally, I believe, like a week ago. I believe it was a French court that ruled, yes, a court of appeals, I'm not sure what exactly it's called, rejected the immunity of the European Space Agency on the basis that it would create a denial of justice. But it's an interesting precedent, I mean, if you can, I understand it's a European agency. And of course, it's much easier to establish jurisdiction in Europe over a European agency. Interpol is nowhere there. I mean, if we compare Interpol with Europol, and please again correct me if I'm wrong, but Europol is under the EU jurisdiction. It's an EU agency. I mean, it's accountable to the EU institutions and so forth. So yeah, thank you, Anna. So it's Cour de de Paris. So it's basically so in other words, Europol is much more accountable, and much more, it's much easier to I guess take it to courts, whereas Interpol it's by itself. It's a planet on its own. And the case of the Bahraini dissident, I'm sorry if I'm mispronouncing the name, Ahmed Jafar Muhammad Ali, who was extradited. Well, not really extradited, according to the media reports. It sounds more like he was just taken from Serbia before his extradition case was even adjudicated on the merits, and taken to Bahrain, and I believe he's now detained. So he sued Interpol in France. I'm not sure, what exactly what stage this case is at the moment, but the attempts are certainly being made. Um, I think that with all the provisions that Interpol sort of, surrounded itself with, right? We have the agreement with the French government, we have the Interpol constitution, we have the statute of the Commission for the Control of Interpol's Rights. They say that the Commission has exclusive jurisdiction to consider complaints related to the use of Interpol's resources, and so forth. I think that maybe the way to sort of, play around that, all this walls of that castle, which in my opinion are not really that strong, the walls I mean, is to try and point the court's attention to the fact that yes, immunity exists. The question is it deserved? And under international law, in my opinion, it is not, because again, there is no due process. Yeah, Anna, please go ahead.
I also wondered when I prepared for this conference, I couldn't find an agreement between the Federal Republic of Germany and Interpol. Although, I mean, I found one regarding the General Assembly meeting in 2005 when Interpol was located in Germany. For that, they had an agreement on immunities. But you have the NCA in Wiesbaden that is also working for Interpol. So you should have some kind of agreement, like the headquarter agreement. And in the UK, you have such an agreement for Interpol, actually, I found. So I wondered how it is in your countries. Do you have for your respective NCAs also agreements on immunity? And if not, would that not be, what does it mean? Does it not imply that then there is no immunity?
I'm sorry, Michelle, you said NCA? Or NCB?
NCB, sorry. Yeah, NCA is UK. Yeah, NCB.
I don't think there is. So again, in NCB here in the United States is a government agency, so it shouldn't be immune by definition from lawsuits. But again, the thing is, okay, say you sue the agency over what? It's not the agencies unless the US NCB submits a request, that's not compliant and so forth. But that would be a violation of the United States laws. But if it's another country, or or Interpol violating their laws or their rules, I'm just not sure how the argument can be made that it's our NCB that's involved in all. I mean, technically speaking, yes, any NCB participates in the processing of information.
Actually, there was this case with the German BKA, the Bundeskriminalamt, the German Federal Police, which is at the same time the NCB for Germany, who requested extradition for someone who was located in Venezuela, and for an offense that had been committed 27 years ago. And then Interpol deleted the red notice from Germany based probably on passage of time. But that was a case where you could have also thought about suing the NCB directly for requesting Interpol to issue the red notice in the first place.
Right. Mm-hmm. I think that I mean, in a case like this, certainly, if an NCB participates in what Interpol calls processing, I mean, if we look at the definition of data processing in Interpol's rules, it's I think it's fairly broad, right? So if an NCB, a National Central Bureau, participates in communicating the information recorded in Interpol's databases at the request of another country, I mean, I think an argument can be made that the violation has taken place. I think it depends on the circumstances of the case, but I think it's an interesting take. I think it's definitely an interesting angle. But again, challenging the immunity itself. I think that I think again, the Interpol has surrounded itself, right? Again, with, I'm sorry for repeating myself, with all this different provisions. I mean, they included that, oh, we're immune in all these possible, international agreements and so forth. But again, fine, they are there, they enforce these provisions, but the immunity is not deserved from standpoint of international law, because we have, again, we have the Commission for the Control of Interpol's Files that I'm not aware of one case in which a hearing was actually held. Like literally, I've never heard of one. There is no right to appeal. I mean, it's just basically non-existent. Not to mention that you can't even examine evidence without the government's consent. Yeah, please go ahead.
Maybe just to compare, and because it's, as I say, it's different times. That's why Interpol has to come to the 21st century also in this regard. Because if you look also at Europol, it also changed from. Of course, there is lots of criticism, but right now Europol is under EU laws and has specific regulations where you have quite specific rules, which we could discuss, and there is also criticism. But at least, like for Europol data processing, there is avenues of complaining and of access to EU courts even in respect of data protection. So this is very different from Interpol. That's why. And I was posting like the European Parliament was demanding that the Commission negotiates an agreement with Interpol that respects the EU rules on data protection. So which, if we take these examples of other agencies, is quite detailed rules on and that include more like proper remedies as we know them. Maybe I wanted also to raise another issue that for NCBs and how complicated this is. I can give you the example of my jurisdiction. In Portugal, you can be arrested on the basis of a red notice directly by the police, so without any supervision by a court or a prosecutor, so it's directly effective. Imagine, even if you were a national of Portugal and normally cannot be extradited, only in very exceptional cases. We've had cases where people are arrested and taken to court, and this takes like 2 days until they finally go to court, and the court will release them because they're nationals and most likely can't be extradited because the exceptions are very narrow. So the law actually states in Portugal that people who are subject of a red notice diffusion, like any message requesting extradition via Interpol channels, may be arrested if the request is based on facts that are clearly wanting, warranting extradition prima facie. So, but this control is not made because, I mean, if you're a national, well, then what they should do is to tell the state, send an extradition request. This way, a court can analyze it before any detention is ordered, and also the Ministry of Justice. But this is not what's happening. And you have no remedies, even if it's a Portuguese NCB, which is part of the Portuguese government, and we could discuss if it's also part of Interpol and who is it a mixed thing, but it is clearly the police and police body. You can't do anything because we don't have a preventive remedy. So even if there is a red notice, well, you can write letters and so on, but there is no adversarial process and there is no means of launching a preventive habeas corpus to have a court to ban your arrest. So this is a huge issue, which in my view, again, underlines the need to have effective controls in respect of Interpol, of the centralized data processing system, so that you don't have to do this. And also, if you can do something at national level, well, then you have to do it all over the world. If you want to move, it's not very practical.
Two things in addition. One is, so this recent decision from the French Court of Appeal in the European Space Agency. So first of all, it confirms what the Labour Law Chamber has said, which is immunity is not kind of always, it can be set aside if there's no proper legal course of remedy and effective remedy, etc. So nothing new on that. It's confirmation, which is a good one. But what is also of interest is that this case is connected with a criminal complaint. And this is also something that is online if you look a bit into the Meng case, where a criminal complaint has been filed before an investigating French judge surrounding events that took place and what one can read in the press that could possibly involve Interpol in criminal participation in criminal events involving the Chinese intelligence services on the first line, but around trying to abduct Mrs. Meng, drag her into places where she would be kidnapped, and that kind of really serious stuff. And in the course of these criminal complaints, obviously, the French investigating judges are confronted with this immunity issue. And this is what happened with this European Space Agency case, where it was about the parents of a young man, I think, who committed suicide, claiming that it was because of harassment at work, with an internal audit report from the space agency confirming apparently that there were serious issues in regards to management, etc., that could give ground for criminal investigation, as there was this very famous France Télécom case. And these are serious criminal issues in France nowadays. And so in this case, the judges who were trying to investigate were sending rogatory commissions, and I imagine to this agency who was not responding. The judges considered they could not raid the premises because of this immunity matter. And it seems that it is in connection also with this criminal process that this Court of Appeal decision was rendered. So there is also this area of considering possible criminal complaint. This is, I'm getting into kind of really big talk now, against Interpol. Would in some cases you have evidence that they have willingly, knowingly, so that's maybe not the CCF, but the CCF is supposed to investigate independently, and would you have grounds to think, or in the best cases for yourself, evidence that, for example, there would have been collusions between NCBs and I don't know who at the General Secretary, who is supposed not to put in red notices without a first review, or that there is at least, I mean, negligence in not having just checked the name on Google of this poor Uyghur opponent, and that it's a bit short then saying when you write to the CCF, guys, this guy has been sent to China, he's in a camp now, a labor law camp. It's all over Google that he's kind of a target. It was over Google when you received this request from the NCB, so that at least is negligence. And when he was sent over and we requested compensation and relief, the CCF answered that there was nothing to be taken out because the notice had been taken out already by the NCB, and it'd been taken out for the reason that the guy was in China. So it's too late, and there's no responsibility to be taken by and the CCF is saying, okay, guys, but we're not making a decision because there's no red notice anymore. So it's kind of, you open, you get the work done, and then it's out, and then so there's no recourse. because there's no notice anymore. And if you bring that before court, I think it won't fly. If you've got one of these cases, and I do even think that if that was brought to an investigating judge, he should possibly be interested in looking into who made the decision at the supposed commission checking prior to putting notices in, whether prima facie there was a reason not to do it. And if you look into what would happen to somebody within a legal entity, compliance wise, I imagine I would not like to be the compliance officer of this multinational company with headquarters in France. So there is this criminal angle, which is a bit frightening because already civil-wise we're not getting it through. So obviously we think, oh, kind of going against Interpol with an investigating judge will be even more difficult, but
Maybe not.
Yeah. Or even with embezzlement within the
and
organization.
some judges like to make also an aim or a career in doing something that has not been done before. So maybe we can try and pick one who will have the bliss to try and do something about that on one poor chap. Then yeah, you would have maybe jurisdiction, a nexus because it's in France, or because the guy is French, or because I don't know. But I
Maybe
don't
just
think that has been tried yet.
to
Yeah.
bring an important information, because this withdrawing the red notice is typical, or because it's executed, or to avoid the challenge before the courts. And in the case that Anna mentions, that was before the Court of Justice, that also happened. So let's say that the person at stake was in Germany and could not be extradited in the case that went to the Court of Justice, because the person had already been tried in Germany, so he benefited from this protection of maybe Sweden, at least in Germany, and then was complaining about the processing of data by the German authorities, which transcribed the red notice, and then this was also transcribed into the Schengen system, if I recall well. But during the case where the person was challenging this, the red notice was withdrawn, and then using the argument, well, the case no longer has an object, it's like so the case should be dropped. This was to try to avoid, obviously, that the Court of Justice would rule on the matter, as it did in the end. But it did not work, because the German courts found that this was not sufficient to make the reference for a preliminary ruling irrelevant, and then did issue a ruling on the merits. Yeah.
Maybe to add to that and also answer I don't know if it's a question from Carlos Duran on Nebis in Idem. You know that the case that Vanya just mentioned also established that you can put an addendum to the red notice stating that the person has already been tried for these offenses that are in the red notice. So if somebody has been tried in Germany, the German NCB can put an addendum to the red notice stating he has been tried, and this should, in principle, release him from the fear of getting arrested within the EU or within the Schengen member states. Whether this works in practice, I do not know yet, but it's at least some development that is thanks to this European Court of Justice ruling, but is of course limited to the Schengen and to the European Union area.
I saw that question about nibis in idem, and the reason I didn't start, I didn't start giggling is because I didn't want to interrupt you, because that's my favorite topic. I mean, Interpol and nibis in idem, we need to do at least 10 webinars on that because it's so bizarre, especially taking into consideration the most recent decisions that the CCF published just a month ago. So, but let's answer the questions that our audience has posed. We don't want them to think that we're ignoring them. We don't. Juliette, I'm not sure I'm pronouncing the name. I won't, because I don't. I'm definitely going to mispronounce it. So thanks. Are you aware of cases in Germany or Portugal where the alternative means doctrine was applied outside of labor disputes? Whoever wants to take it, go ahead.
Vanya will take that. Just one word. Hi, special hi to Juliette, who was one of the most incredible interns I ever had, and I desperately wanted her to come and work with me, but she is so good that she decided to have a career in where proper lawyers are, meaning in the university, and she's working on a thesis. So that's for Juliette, and her question obviously is so high level, I don't know how to answer it, but maybe Vanya for Portugal.
No, I wanted to start by also acknowledging, because Juliet was working also on these matters, and so she's even more expert. So it's all difficult to answer her question. But I don't know any case where the Portuguese courts have applied this outside of labor dispute. I'm happy to review this for you and give you an update. But there was an interesting case where someone tried to sue the Council of Europe because they were not happy with the decision of the European Court of Human Rights to declare their complaint inadmissible. But you can imagine where that went. No, it was not very successful. But anyway, so I don't know, Juliet, so far. I will update it, but of any case in Portugal where this doctrine was applied in other areas of law other than labor disputes. Typically, we have lots of cases of labor disputes also concerning embassies, diplomatic representations, but then these end up, if people are not from Portugal, they end up going away, and there are other types of issues that could maybe be the basis for launching a case. They normally don't end up in court somehow because the people who let's say cause an accident, for example, leaves and goes back to their home country if they were working in an embassy. So, but I will review this for you. Thank you for this question. And I'm looking
Same for Germany. I can also review it for you, but I am not aware of any cases. I'm not aware of many cases in Germany in general on this immunity matter, but I will check if you write me an email.
I think it's interesting to look at the countries who do have international organizations sitting there. It's the case of Portugal. We also have for the UN a few, like for drugs and EU drugs agency and so on. So I'm going to check if something came up.
William, do you have anything to add to this?
No, I think for France we've got quite a lot, and the social labor law related, and now this very, very promising new decision connected with this criminal complaint. So I really think the lines are moving, and I guess Interpol knows it, and they know it because, if I'm not wrong, they received 2 summons recently, and they might get another one coming. So I'm sure they have guys working on the matter. And I think we should really start working on this European GDPR thing, which is fairly technical. I know with Vanya we started to kind of try and see how we could work around this, but I think that this angle of, bringing some EU complication to the French judge could be a really good thing to consider. But I think we're going to see things, Yuriv, in the months coming. Civil cases take some time, but by next year, same day, I think we'll have some real developments to discuss again. The lines are moving.
Maybe
So this is.
Oh,
yeah, go ahead.
Sorry,
Sure.
Don't want to interrupt. Just this discussion is really interesting, and I think for me, and for all of us, maybe the thing is, why is immunity justified in the time we live as we are today? And there may be instances where immunity is justified, but when you look at an organization and that is dealing with really sensitive data that can imply arrest, extradition, torture, but not only that, even that you cannot leave because all the banks close your accounts and you cannot leave without a bank account, at least in in Europe, or I guess in the US. So is immunity still justified? I mean, if there is immunity, I think nowadays no one can deny that it has to have really strong safeguards. So there has to be a proper, let's say, internal court mechanism where people can actually get proper redress when their rights are violated. I think this has to be the way.
So we had, I think, a great discussion. I personally enjoyed it, and I thank my co-panelists today, and I hope our audience enjoyed it too. Thank you for all your questions. This is a very important and huge topic, and I'm sure we'll continue. We'll discuss it at least once again, if not more. Probably many more times than that, because it's developing, and I think we'll need to continue covering it. I thank everyone for participating, both the audience and my co-panelists, and we'll see you soon again during our next webinar. Thank you again very much.